Thank you. Question from the jury. I think it's safe to say it's a two-parter. In order to find her guilty of criminal damage to property, we do not need to confirm her intent was to injure him, correct? We do need to agree her intent was to shoot the door and that a natural consequence of shooting the door caused his death, correct? My initial reaction is the first question is easier than the second question.
That's what Anna just said. You should reread the charge.
I think the answer to the first question is yes. I think the answer to the second question and the proper thing to do is to recharge on criminal damage to property in the first degree.
As well as causation in felony cases, Judge. Felony murder.
Well, they didn't ask a question about the felony murder.
Well, to me, the second part of the question is kind of combining felony murder. Because it says the natural consequence of the shooting of the door is what caused his death, which to me is going to the felony murder.
Let's go one at a time. Any proposal on the first part of the question?
Yes.
Just simple yes?
Yeah, we do not need to so the question was, we do not need to confirm her intent was to injure him, correct? And I think we could just put yes or correct.
Defense?
With respect to the first question?
With respect to, we do not need to confirm her intent was to injure him, correct? Question mark. Underline, not underline intent.
Correct.
Are you ready? So what I propose is we label it 1, and Mr. Preston, if you don't mind retyping the question, including the underlines, and then the response is correct. All right, catch up on that.
What did she do? Yeah, that's what it leaves out. It's almost 2 parts. It's almost 2 parts. But as the cause of death is talking about causation. And they're kind of conflating the two. Natural consequences. It's not a natural consequence. second answer is probably agreed. The intent is knowingly, without authority, endangering property in there. All three. That's the intent. That's three.
You good with that?
Yeah.
State's proposal on, we do, underline do, need to agree her intent was to shoot the door and that a natural consequence of shooting the door, parentheses, or brackets, caused his death, close parentheses, correct, question mark.
Judge, we would propose that Your Honor bring them out and recharge them on criminal damage, felony murder, and the causation. Right.
Hold on a second.
Yeah, just the felony murder obviously as to criminal damage.
Two 26820, criminal damage to property in the first degree. I'm sorry, what else?
The felony murder charge as to criminal damage.
Page 8, is that correct?
Yes, let me triple check.
On page 8?
Yes, Your Honor.
21020,
Then it's just a question. Right.
Where's the causation?
what else?
I was trying to find it in the packet. Give me 1 second, Your Honor. The causation in felony murder 21030 on page 9.
Any other proposal?
That's it, Your Honor.
I have state's proposal 21020, felony murder, 21030, causation in felony murder. Page 11, 26820, criminal damage to property in the first degree. Defense.
Yes, sir. So this was part of our requested charges, was to tell the jury specifically that knowingly applies to each of the elements that follow it. So I think at this time, it'd be proper to give them that correct statement of law, that knowingly, that her intent must be to knowingly, without authority, knowingly interfere with property, and knowingly in a manner so as to endanger human life. Because they've asked very specifically for that, and it is correct. And to leave that out when they've asked the very specific question about intent and which of the elements it applies to would be a mistake. So our position is, and I think, frankly, respectfully, I don't think the court has a whole lot of leeway with what they've asked for. They're asking for the intent. Does the knowingly, what does knowingly apply to? And it applies to all the elements, which would be knowingly without authority, knowingly interfere with property, and knowingly in a manner that endangers human life.
I'm not saying I'm necessarily going to give it or not give it. What was your request to charge number on that?
Give us just 1 second, Judge.
$46 maybe?
Yes. Thank you. Drop the last paragraph. Yeah.
This is their request. And now they want to read. Yeah.
They're charged on that. That's already being recharged.
Yeah, we object to the reading of this charge, Judge. This charge has already been denied. There's a lot of stuff in here that they're not even asking about as far as the without authority and who has legal right and privilege to the door and like all these things. This just goes way beyond even what their question is. I think it's perfectly proper for Your Honor to reread the instruction that's already been given to them. And not to now add a new charge they haven't heard yet that also includes information that they're not asking about.
I think if you leave out the last paragraphs, Judge. Sorry, what? If you leave out the last two paragraphs of defendant's request 46. And you could even put knowingly without authority, knowingly interfered with property, and knowingly in a manner that endangers human life. In other words, it would just be set out. Instead of in one, you'd put knowingly without authority, knowingly interfered with any property, knowingly in a manner that endangers human life. And that would get exactly the same thing. And you could even cut out the paragraph below that.
They're asking.
They're asking about the intent, and that is the intent that's required. So I would say you can cut out everything below 4. You just put knowingly without authority, knowingly interfere with property, and knowingly in a manner that endangers human life. The defendant acted, I guess would be the word after the.
Yeah, I hear what
Okay.
you're saying. I don't think that.
May I approach, Judge? I just marked it up.
Can you show it to them?
Yes.
Thank you. State?
Judge, I don't think that we should be charging them on anything other than we've already charged them on, and reread the charge as pattern that we've already read for criminal damage, felony murder, and causation of felony murder. I think it would be improper to start adding things to a charge. Your Honor's already declined defense's request to charge, and I don't think that it's proper to now change the charge that they already have. I believe that what we've charged them on is pattern, it's the appropriate law, and that would be the appropriate response to their question.
And the appropriate response to the question is the correct statement of law on the exact issue that they've requested.
Which is the pattern, right?
No, they've asked specifically about the intent. Does it apply, and what does it apply to? And it's correct to tell them that. And to leave it out, and they don't know knowingly applies to the conscious disregard. And that's the gravamen of the offense.
Yeah, there's no conscious disregard in.
Well, to the whatever, to the last element. And knowingly endangering human life.
Yeah, I mean, the correct statement of the law is the statute. That we shouldn't be adding words to the statute. The statute is the correct statement of the law. The statute is what the pattern charges and what we've already charged them on. It's not an incorrect statement of the law to charge them on the statute.
They've asked.
Well,
Again-
hold on. I'm certainly going to charge them on page 11, 26820. I mean, that's going to happen. So, I mean, that's,
So
so hold on. So the only question is, with their specific question, do we go a little bit further? And here's where, I mean, on the first one, it's correct. On the second one, it's, we're not going to tell you whether it's correct or incorrect. We're just going to read you again, which is, may very likely be what happens, and that's fine.
And so how?
I mean, they're partially right, partially wrong. I mean, yeah, kinda. I mean,
How about we charge them also on intent? If their question is about intent, there's literally a pattern jury charge on intent, 14110. We charge them on the pattern jury charge of intent so that they know that criminal intent does not mean an intent to violate the law, but means simply the intent to commit the act. It also talks about how intent is an essential element of any crime. It must be proved by the state beyond a reasonable doubt. Like it covers all of that as far as intent. And then charging them on the statutes for the two crimes that they're asking for. That is all correct statement of the law, and it's a direct to their question.
They're only asking about intent as to one charge. They only have a question about that, and they specifically put in their question, we do need to agree her intent was to shoot the door, and then they make a mistake, and they say a natural consequence of shooting the door. That's incorrect. And then they put in parentheses, endangered human life. Her intent has to be to knowingly endanger human life. That's the correct answer. That's why we have to tell them that. We don't just go, well, intent generally is this. They're asking about this charge. The intent is knowingly endanger human life, period, in the story.
Yeah.
go ahead.
I think that's a complete misstatement of the law.
Which part? The knowingly part?
The knowingly endangering human life. She has to knowingly commit an act, which in turn endangers a human life. She has to knowingly commit the act, which is shooting at the door, and that act.
Hold on, let me run this by Alan. I'm not saying I'm going to give it. For the charge of criminal damage to property in the first degree, the state must prove beyond a reasonable doubt that the defendant knowingly interfered with the door without authority in a manner that endangered human life. Knowingly means she was aware of her conduct. It does not require proof that she specifically intended to damage the door for its own sake or she intended to injure the victim.
I don't think that's correct.
Yeah, I
Okay,
think
that's fine.
I think the knowingly is.
See, here's where we get into it because it's not quite correct. And if we're just going to read what they already have. I mean, they have a copy of this back with them.
The shortest answer.
Without, answering their question.
And they've asked specifically just about the intent about criminal damage, and specifically with respect to endangering human life. The correct answer, the answer that is clearly the correct one, is they have to prove that she knowingly endangered human life.
That is
That's the answer.
incorrect.
That is correct.
That is incorrect.
One at a
The
time.
rule,
Go ahead.
the rule started in the United States Supreme Court with the Flores-Figueroa case, which was extended into our Scott case that we put into our brief. When the word knowingly is put in a statute, it applies to every subsequent element of the offense. That was the trafficking statute that struck down the trafficking statute about whether knowingly applied to the weight. And our Georgia Supreme Court, following the U.S. Supreme Court, said, when you see knowingly at the beginning of a statute, it applies to all the subsequent elements. And they're asking specifically, they're saying, hey, what is the intent? Is it just that it's a natural consequence, but then they put parenthesis, endangered human life? They're asking, does knowingly mean knowingly endangered human life? Because that is the element that has to be proven by the state beyond a reasonable doubt. It's the correct answer to tell them, knowingly endanger human life. There is no argument to the contrary that's correct. This is the law. Knowingly endanger human life, period.
All right, state.
Judge, that's incorrect. The element is interfered with any property in a manner that endangers human life. He's separating elements. You don't have to knowingly endanger human life. The intent is committing the act. The intent in this crime is you have to intend to commit the act. That act endangered human life. It is that he knowingly and without, it's that she knowingly and without authority interfered with property in a manner that endangered human life. She has to knowingly interfere with that property, and in doing that act, endangered human life. He is incorrectly stating the law. My computer's not working, I'm trying to pull it up. But the knowingly does not apply to in a manner so as to endanger human life. That is an incorrect statement of the law. That is why that would be incorrect to add that into the pattern. He's separating one element into two and adding knowingly where there shouldn't be one. There is an intent to knowingly commit the crime. She has to knowingly commit the crime, not knowingly endanger the human life. He is misstating the law. That's why I propose reading the statute and the pattern as charged, because that is a correct statement of the law, instead of adding the word knowingly in front of lines where it doesn't apply.
And the reason it's knowingly, in addition to the fact that that is the law, is because she has to knowingly be endangering human life. That's the scienter. This is the gravamen of the offense. Knowingly endangering human life. She can't unknowingly endanger human life and be guilty of criminal damage first. That's not the crime. The crime is knowingly endangering human life. Doesn't mean she has to intend to take a life, but she has to knowingly be endangering it. It is a criminal negligence offense, in essence, knowingly endangering human life. They've asked specifically, and they're conflating natural consequence of the act with what the actual element is, which is knowingly endangering human life.
Okay. Give me a second, please. All right, well, is your computer up to speed?
What I've been, it's freezing off and on. The case law I found, Judge, basically says that, like the one that I was trying to read right now before it froze, was saying that the knowingly as part of endangering human life for the criminal damage means reckless endangerment rather than actual endangerment. So like you can commit criminal damage to property when no one's even in the building and you shoot into an uninhabited building. And so it's more so you're knowingly committing an act that could endanger human life. I've also seen examples of arson where arson also includes the language knowingly, and it had the same exact, basically it's more of a reckless than it is an intent to injure or an intent to endanger human life.
All right, so let me interrupt, and we'll talk about this a little bit further. Is there a point in bringing them back and me rereading what they already have back there? Or do we say, look at page 6, page 8, page 9, page 11?
I mean, that's fine. I think it gets the same effect across.
I think there is. I think we have to answer the second question with a correct answer. I think the correct way to deal with it, respectfully, may I remain seated?
Yes.
Would be to answer your first question. We do not need to confirm her.
So the answer to the first question, we do not,
Yeah.
the response is correct. And so
Yes.
I've already written up, and I intend to send it back to them, is we will address question 2 in court, which we can do, or I can change it and say,
I think-
read these 4 charges in this order.
I don't.
And I understand you disagree with that.
Yes, sir. I think that we have to answer both the questions for them correctly. And I think the answer to the first question is yes, but to then not include the answer to the second question is highly confusing to them. The answer to the second question is, we do not need to agree her intent was to we do need to agree her intent was to shoot the door. They're just talking about the act. And that a natural consequence of shooting the door caused his death. Not correct. Not correct. We do need to agree that her intent was to knowingly interfere with the door and knowingly do so in a manner that endangers human life. That's the correct answer to the exact question that they've given. And I don't think that we should split it up, the answers, because they're asking all around the criminal damage intent. The correct way to do it would be, the answer first one is yes. The answer to the second question is, we do need to agree her intent was to shoot the door and that she did so knowingly, without authority, and knowingly in a manner that endangers human life.
And Judge, many times the correct answer is just to read them the appropriate charge.
I agree that in a large percentage, I do have concerns that they've narrowed in on a very narrow issue. So I mean, my initial inclination is just to either reread or point out charges to them and see if they have any follow-up on it. That's my initial reaction. However, I do find somewhat compelling defensive argument to try to be as specific as possible with the correct statement of law. And I understand that the parties disagree on what the correct statement of law is or is not. State, do you need more time on anything?
No, Judge, just that I'm just continuing to read cases that all say the same thing as far as the endangerment of human life, that the courts consider it more of a reckless endangerment than anything else, because you can commit the offense of criminal damage in the first degree by shooting into an uninhabited building. And so, again, it's just you're knowingly committing an act that whether or not it actually does endanger human life, it's basically reckless to do so because it could endanger human life, is what all these cases are saying, which is why the state's argument is that to put in there that you have to knowingly endanger human life is an incorrect statement of the law, because you don't necessarily have to actually endanger human life. You just have to knowingly commit an act that is basically reckless endangerment because your act could carry with it the possibility of endangering human life. That's why state's position is that Mr. Willis's statement of the law is incorrect. And I was looking specifically at 272 Georgia 378, which is a Georgia Supreme Court case, Carthern v. State.
That's frozen again. I have one.
Oh, okay.
It's working fine. You can take it.
Defense, you had something?
Just going to restate that I think we tell them, answer your first question, and then state the question is yes. Answer to the second question, we do need to agree her intent was to shoot the door and that a natural consequence of shooting the door causes death, correct? That is not correct. You need to agree that her intent was to shoot the door and that she did so knowingly and without authority and knowingly in a manner that endangered human life.
That's the point. That's aggravated assault. I mean, it's just an incorrect statement of the law. Every single case I've read on criminal damage to property over and over says it's a reckless endangerment, not an intentional endangerment. You don't have to knowingly endanger human life. You knowingly commit an act that could endanger human life, and so your act is essentially reckless. You can shoot into an empty building,
So
not a single
let me
person's in
interrupt.
there.
So what we're going to do is I'm going to direct them to reread certain parts. I'm not going to invite a question. If they have a question, essentially, Judge, that's not what we asked you, then we'll see where we go from there. So defendant's specific request is denied. Any preference of order, or just say, look on these pages with this number?
Just chronological order of pages is fine, I think, makes the most sense.
We're saying yes.
Yeah, he's saying correct
Yes.
for the first one, and then the pages for the second one.
So it will be something along the lines of this. Question 2, please look on page 6, 1.41.11, no presumption of criminal intent. Return. Same verbiage. Please look on page 8, 2.1020, felony murder. Same verbiage. Please look on page 9, 21030, causation in felony murder. Same verbiage. Look on page 11, 26820, criminal damage to property in the first degree. That's our first step over defendant's objection. I'll take inquiry on that. I'll allow defense to preserve their record if they need to.
I'll do so after the charge of the court. Thank you.
I think they're just turning it up. No.
For scheduling purposes, I will go as long as the jury wants to go today.
Yes, Your Honor.
For, and I'm not blaming anyone, but for sheriff department, et cetera, we will not have court on Saturday. So if this goes past today, it will be on Monday.
Yes, Your Honor.
print out a bunch of them for them.
These are. Yeah. Thank you. No objection, Judge.
Same objection.
Same objection is noted for the defense. This question will be labeled C7, Court 7, and will be given to the court reporter in a moment. I will send a copy back of their question so they know what it was, just in case they might have forgotten. I'm going to do basically a duplicate original of C8, which is signed and dated by me. Madam Court Reporter, C7, C8, please. Thank you. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No, sir.
Chief Bailiff, I'm going to hand you a copy of their question. And then I'm going to hand you a copy of the court's response. Thank you.
And at this time, since we're sending the response back, I guess I'll just restate our objection officially to the charge in response to the juror's note. We're renewing our previous. I'm sorry? Yes, okay, but I have just a second.
Yes.
We're just renewing our objection and requesting states.
You can go ahead and take that back. Thank you. Go ahead.
We're renewing our objection to the states, to the court's response to the jury's note, and asking for a ruling on our objection to the court's response to our objection.
Meaning your proposal.
Yes,
Okay, to be clear, that proposal is denied for legal purposes.
thank you.
All right. Anything else?
No, sir.
No, Your Honor.
Okay. No comment one way or the other. Don't go super far just in case they review it and go write another note. But I'm going to step off the bench and they may not respond or they may respond immediately. All right?
Your Honor.
Thank you.
He'll even say, hi Matt, nice to see you again. He's like you. Yeah, someone said, hey Matt, nice to see you again. I'm glad you're back.